Hello, I'm Paul from Bezla, and I'm going to look today at seller representations and warranties in hotel purchase agreements. Purchasing real estate that includes functioning businesses is complex and risky. The information available during the short due diligence period is limited. Sellers will usually have knowledge of the assets, and obtaining representation and warranties can reassure buyers that they receive accurate and complete information. From the buyer's viewpoint, the purpose is to make the seller disclose facts that, together with ordinary due diligence, allow an informed decision. Sellers are often reluctant to provide meaningful representations and warranties, preferring to sell as is. Buyers, on the other hand, want a complete list of unqualified representations and warranties. Ultimately, buyers want to know what the seller knows. Therefore, in the majority of situations, representations and warranties that relate to condition of the property or its operations will be based on actual knowledge of the seller or of key employees. Typically, representations and warranties cover three general areas. First, the seller, their status, that they're not a foreign entity, a debtor in bankruptcy or otherwise the subject of an insolvency proceeding, that all necessary consents have been obtained, and that they have right and authority to sell. Buyer's counsel should independently verify these details. Second, the purchase agreement should certify that there is no conflict with other obligations of the seller and applicable law, and that under all circumstances, including bankruptcy, the agreement is enforceable against the seller. Thirdly, the status and condition of the property and business. Along with the results of the buyer's own due diligence, these are intended to make the seller disclose facts for the buyer to make an informed decision. We suggest the following additional considerations. The seller represents that there are no condemnation proceedings pending or threatened unless specifically disclosed. The seller represents that there is no litigation pending or threatened unless specifically disclosed. Normally, the seller will try to limit representations and warranties on violations of law or CC&Rs and other items of record by stating that they have not received written notice. There should also be a statement regarding who bears the risk of violations discovered during escrow. The buyer wants assurance it will not be liable for cost of environmental conditions or claims for the period preceding its ownership. The seller will usually agree to a representation and warranty that no ground or space leases exist, or state that only scheduled leases exist. In this latter case, the buyer should request e-stop-els from the other parties. The ability to sell the property free of all liens may be addressed through proper title review, along with a covenant to sell the property free of all liens, excluding permitted exceptions. Purchase agreements typically state that the buyer will assume certain contracts. In this case, the buyer will require representations and warranty that only the scheduled contracts exist and that none are connected with any default. The seller should represent and warrant that full and accurate financial and operating statements used in making property operation decisions have been provided. The seller should be willing to represent and warrant that no third party has purchase or lease rights. With branded hotels, this is particularly important, as many franchise and brand management agreements provide for a right of first refusal. Ground leases should also be carefully reviewed, as they often contain such rights. The buyer should confirm that seller has paid all taxes and assessments to mitigate the risk of successor liability. Buyer's due diligence should include comprehensive physical inspection by qualified consultant or contractor, but buyers should also require to know if sellers are aware of any defects. If the buyer or seller, directly or indirectly, is contributing to a pension plan subject to ERISA, plan details should be provided. The buyer should confirm that the seller is not on any government list or the subject of criminal investigation relating to money laundering. Hospitality is a seller's market. Representations and warranties tend to be lesser than in other market environments. Sellers would prefer to make no representations and warranties, so they are free from worries about buyer claims. Buyers want to know they have all information relevant to the value of the property or business. Ideally, buyers would like sellers to be financially responsible for any surprises, at least those that were known to the seller. If both parties are motivated and reasonable, there is usually a compromise. If Bezla could be of assistance to your hotel marketing, visit us at bezla.com or give us a call at 888 999 8086. Thank you for watching.